And we're live. Hey folks, welcome to this week's Lawfare Live, coming to you live from the headquarters of the Hewlett Foundation in Palo Alto, California. Thank you to Hewlett for letting me use the conference room. I am here with the estimable Anna Bauer, the estimable Preston Marquis, the estimable James Pearce, the estimable Scott Anderson, and the very estimable Roger Parloff. And guys, we have a really, I think the technical term is a boatload of stuff to go over. So let's just get into it. And let's start with the arrest of a Wisconsin state judge for obstructing justice this morning. James, walk us through it. What do we know about this case and what this judge allegedly did?
Yeah, thanks, Ben. I mean, it is, as you mentioned, a story that's just broken today. So I'm sure we'll get in the following days more facts, but at least based on reporting and the criminal complaint that the government has filed in the Eastern District of Wisconsin, we know the following. So Judge Hannah Dugan, who is a Milwaukee County Circuit Judge up in Wisconsin, was arrested today on probable violations of both an obstruction statute, 18 U.S.C. 1505, and a statute, 18 U.S.C. 1071, of essentially harboring someone with a known arrest warrant. The facts, according to the criminal complaint, are basically that an individual by the name of Eduardo Flores Ruiz was slated to come before Judge Dugan for a hearing in a criminal case. So Flores Ruiz is originally from Mexico, had been removed at some point, I think maybe in 2013, to Mexico, came back into the United States seemingly without permission, and then at some point in March of this year was arrested in connection with state charges, I think domestic abuse charges. And so on April 17th, just a week or so ago, he was due to appear before Judge Dugan for some kind of a scheduling proceeding. Federal authorities, in particular the Immigration and Customs Enforcement, ICE, caught wind of this and either had in place or shortly thereafter secured an arrest warrant, administrative arrest and removal warrant, and then made plans along with the FBI to execute that arrest in the public courthouse in Milwaukee, where Judge Dugan was practicing. I should pause for a moment and say it's actually not all that unusual for federal authorities to carry out arrests in state courthouses. This happens sometimes in the immigration context, happens perhaps more often for individuals who are facing state charges, but also have federal charges against them. As the criminal complaint lays out, it's often a place where federal authorities have a pretty good sense that that's where someone is going to be. Individuals have had to usually pass through some sort of security, so there's a way to downplay or at least try to minimize security concerns. And by and large, the federal authorities try to do it without a whole lot of Sturm und Drang, right? In fact, here the criminal complaint identifies that the officers, the ICE and FBI officers, were in plain clothes, were kind of waiting outside the hallway. Somehow Judge Dugan finds out about the existence of these federal authorities. And I should say, just in case it's not clear, everything I'm saying comes from the criminal complaint. So, there hasn't been tested in a court, but this is what we know. Judge Dugan learns about this. The complaint said, quotes her as saying something like, "It is absurd that these federal authorities are here." Goes out into the hallway where the ICE and the FBI agents are, confronts them, suggests that they aren't permitted to actually be in the courthouse. They say, well, we're in a public place. We're trying to execute an arrest warrant. Judge Dugan and another judge, identified in the complaint only as Judge A, essentially escort all but one of the federal authorities down to the chief judge's chambers. The reason that the last one isn't seems to be that He's not identified, or he or she, I'm not sure, is not identified as part of these federal either ICE or FBI agents. Again, they're all in plain clothes. I don't think this last one identifies him or herself, so is able to kind of stay and watch what happens. So the federal officials go down to the chief judge's chambers. The chief judge is not there. They get the chief judge on the phone, and there's some sort of a back and forth about whether this is proper and whatnot. While that conversation is happening, according to the criminal complaint, Judge Dugan goes back into her courtroom and essentially quickly moves Flores Ruiz and his attorney kind of out the back door. They don't seem to go through the proceeding that was scheduled to happen. The criminal complaint suggests that the prosecutor, the state prosecutor, is sort of surprised to see Flores Ruiz exit. That exit happens. The one individual from the federal authority who was left behind, didn't go down to the chief judge's chamber, sort of sees that. Essentially, a bit of a chase ensues because Flores Ruiz and his attorney are trying to leave the building. The federal authorities learn about this. They go down and they arrest Flores Ruiz, who at some point, according to the criminal complaint, runs off, but is caught. And so he is still caught, presumably served with the removal warrant, and that part of the story sort of falls out. That all happens on April 17th, as I mentioned. Just today, following an arrest warrant or a criminal complaint that issued yesterday, federal authorities went ahead and arrested Judge Dugan for the two statutes that I mentioned, obstruction and harboring a known person with a known arrest warrant. As some of the reporting has indicated, the facts in this case, as at least depicted here, are pretty closely parallel something that happened in Massachusetts a few years ago and also resulted in the bringing of criminal charges against a state judge there. With those charges were obstruction charges, 1505 and then 1512 C2, which has had its own odyssey for any of you that have followed that case. So we don't know exactly where this will go from here. Federal authorities, under the rules of criminal procedure, have 30 days now that the arrest has been executed to decide whether by indictment or information, and these are felonies, so they would need, absent the Judge Dugan's agreement, to go before a grand jury to see if there will be an indictment. But that is where we stand. And as I said, all of the facts that I have given here stem from that criminal complaint. We have not heard Judge Dugan's side of the story or from other witnesses.
All right. And of course, the reason this story broke so publicly was that FBI Director Kash Patel tweeted about it this morning and then removed the tweet. Is that correct?
That's right. And when questioned about it, the FBI had nothing to say. So it's a bit of a black box as to why that happened. But yes, that is, I think, what brought this to quickly to prominence. A mystery as to why the tweet and why the quick removal of the tweet.
All right, so let us move from there. We will obviously return to this subject as it develops and ripens. But for now, let's move on to the Alien Enemies Act cases. Roger, we've had a fair bit going on in them. So give us the rundown. Let's start with AARP, which is, just to remind everybody, not the American Association of Retired Persons.
It's not. And in fact, they've changed the name at the district level, court level, but not at the Supreme Court level. So I'm not sure what to call it. Let's call it AARP. There was a remarkable order issued by the Supreme Court Saturday morning. And the timeline there is really interesting. The case was filed Wednesday in the early morning hours by ACLU. They'd gotten wind that a whole bunch of Venezuelans were being flown to this facility Bluebonnet facility in Northern District of Texas. And as you remember, you can't fly out of Southern District anymore because there's a TRO in effect, but it's only district by district. So it looked like they were going to try to fly them out of the Northern District. So ACLU rushes into court about 1 a.m. The Judge James Hendricks does nothing for over a day. And then at about 2 p.m. on Thursday, he denies the TRO. He says that DOJ is pledging not to deport the two named plaintiffs, and he trusts DOJ or DHS not to deport anyone else without reasonable notice. A few hours later, they get the ACL learns that in fact people at Bluebonnet are receiving notices that they will be shipped out either that evening or the next morning. ACLU thinks maybe the judge will be interested to know that they misled him, and the League Alert leaves a message that evening saying it's an emergency. They're getting notice. They may fly out tonight or tomorrow. And a notice appears on the docket saying, if you have an emergency motion, you must file it. And then the government gets 24 hours to respond, and then I'll rule on it. So so now we go into the early morning hours of Friday. They file an emergency motion at 12:43. Nothing happens for over 12 hours. And they're panicking at the ACLU. And so at 12:48, Gallant asks for an emergency status conference and says, look, if you won't rule, we're going to try to appeal you at 1:30. And 1:30 passes. And in fact, 3 o'clock comes around. And so they file emergency appeals. Finally, at 5 p.m., Hendricks rules. He says, you only gave me 42 minutes to rule, which is wrong. That was 42 minutes between the status conference request and the 1:30, but he actually had 14 hours and he actually had almost 3 days. And he also says, by the way, you appealed, so I don't have jurisdiction anymore. I can't help you. And so they run to Boasberg in DC. Around 5:30, he can't help them. He's very sympathetic. He sees the notice is inadequate. So nothing is happening. And finally, the Supreme Court steps in at about 1 a.m. on Saturday to stop anyone from being shipped out of that district, Northern District of Texas. Technically, they can still be shipped out of other districts. And that's where it stands. A few hours after it ruled, the Fifth Circuit also denied any relief. And they repeated the 42-minute thing that 42 minutes wasn't enough. And at the Supreme Court level, 2 justices, Scalia writing, dissented, repeating the 42 minutes thing. So that now at the Supreme Court, it's been fully briefed. So I really don't, I'm not sure what's going to happen there. I guess we could get some sort of ruling at any time, but it's in an odd posture because, it's in an odd posture, and you wonder if they're going to. I don't think they want to issue a national injunction right before they're going to take up the whole issue of national injunctions. Anyway, that's where it sort of stands.
Just a clarification, as some people have noted in the chat, when Roger says Scalia, he means Alito.
I do that a lot. I'm sorry.
I do it too, and
I can't imagine why.
All right, so we don't really know where. I mean, at this stage, what is happening in this case, right? We don't really know the answer to that right now, right?
That's right. Yeah, I'm trying to remember where this. There's so many of these cases.
The Supreme Court puts a hold on it, says you can't go forward. With anybody, but now what?
Yeah, because of JGG, you remember the JGG case.
And we are coming to that momentarily.
But, the court decided that these had to be brought in habeases. And so you couldn't have, that what was before Boasberg was an attempt to deal with some of these problems on a nationwide class action basis. But the habeases have to be brought where the person is confined. And that means one of the 94 districts. And so we have TROs affecting at least 3 districts now: the Southern District of Texas, Southern District of New York, Western District of Pennsylvania, 4 districts, the District of Colorado. So, but the others are sort of still fair game. And we're going to find out. This one is about the Northern District of Texas. So I think that's
right. All right. So let's talk about JGG. James, we had this very powerful pre-contempt ruling from Judge Boasberg, and then an administrative stay. Bring us up to speed.
Yeah. So, as you note, Ben, and we talked quite a bit a week ago about Judge Boasberg's probable cause of criminal contempt, not a criminal contempt finding, that bottomed out with essentially as 2 potential paths forward, saying the government could start thinking about purging its contempt by belatedly taking efforts to comply, maybe even facilitating efforts to comply with his order, or Judge Boasberg would potentially go down the path of seeking either the government to prosecute, or more likely appointing a special prosecutor to prosecute a criminal contempt case. That triggered, as we noted last time, a notice of appeal as well as a motion to stay. Not a huge amount of news except some procedural jousting at the Court of Appeals, but we have had 3 filings this week and likely to see another one on Monday. The government's motion to stay basically argued, look, the district court here is going down 2 unconstitutional routes. So we need relief. Either the court is going to take away the prosecutorial function from us and unconstitutionally appoint a special prosecutor, or it is going to come in and sort of run the foreign policy of the United States as an unelected judge. So Court of Appeals, we need you to get involved. This is a great constitutional harm, and therefore you have jurisdiction. The Court of Appeals, the emergency panel for this month that we've talked about a couple of times, Judges Pillard, Katsas, and Rao, put an administrative stay on the case to allow for some briefing, allow it some time to kind of figure out what was happening. That emergency panel directed a response from the plaintiff appellees on Wednesday, and then a reply for the government today. The plaintiffs responded in 2 ways. They first moved to dismiss the appeal for lack of jurisdiction, which is something we touched on a little bit last week, which is it's very hard to see how Judge Boasberg's order is an appealable order. As a quick primer, an appealable order has to be a final determination. Absent that, essentially you need to either establish that it is something called a collateral order, which has various factors, or use mandamus, right?
But James, isn't everything appealable by the government now? Because it seems like since January 20th, we have a new principle that TROs are appealable, which didn't used to be the case. And now every TRO gets appealed and the Supreme Court doesn't seem to mind. Aren't we in a new world where the rule is a non-final order is appealable if the appeals panel doesn't like it enough?
I think that there's a case to be made that the way we are proceeding, in fact, is starting to carve that world out. I can tell you that's not a world the government is going to like long term, because the government itself, when litigating and trying to sort of beat down attempts by litigants on the other side to get an appellate court intervention early is all the time making the types of arguments that we see the plaintiff challengers making here. This is a non-final order. This burdens unnecessarily appellate courts. But I think it's a fair point, Ben, and certainly, I mean, this at this point, the JGG case is not on appeal from a TRO, but certainly the fact that the Supreme Court took the case on a TRO, although some justices writing separately to say this is a real problem and this is not this is going to create an administrative headache long term, doesn't seem to be something that has paused the court. But nonetheless, the plaintiffs filed their motion to dismiss, also opposed the government's motion to stay, making those the kinds of doctrinal arguments that doesn't warrant mandamus relief, not a collateral order, not something that it's very much premature for the Court of Appeals to get involved. The government filed a reply today, didn't really answer those questions, just kind of said again, these are very grievous constitutional harms. It's either an unconstitutional usurpation of the prosecutorial function or the foreign policy function, and thus Court of Appeals, you ought to immediately vacate this order. The Court of Appeals, the DC Circuit's not going to act because they have also now given the plaintiff appellees a reply. Remember, their filing was, in addition to opposing the stay, was their own independent motion to dismiss. So they now have a reply in support of their motion to dismiss on Monday. And I'd expect that we'd get some kind of action on this next week. That may be an oral argument. We've been seeing a lot of those, or it may be a resolution on the papers. Obviously, we'll come back and report on it, whatever it is.
All right. Roger, we have also had movement in the DBU case. I can't keep all these four initial cases separate anymore. We've got a DVD case, a DBU case. What is the DBU case, and what movement do we have in it?
The DBU case is in Colorado, but before I mention that, there is a movement in the JGG case too. At the district court level, the Boasberg level, because this morning in the early morning hours, a little after midnight, we got the plaintiffs, or the ACLU, filed an amended complaint, a motion for a preliminary injunction, and motion for class certification for two new classes. One is the class of everybody, or at least 137 people probably at Sakat, the people that were moved despite Judge Boasberg's order under the Alien Enemies Act. And so 7 individuals who are there, some of whom you might have heard of, like the plaintiff Andre Romero. He's the gay makeup artist. He's there, and so 7 of them are moving and they're seeking basically an order facilitating their return. The theory for filing in DC goes back to a Guantanamo case called Rasul versus Bush, which allowed Guantanamo prisoners to bring a habeas in DC because they couldn't bring it in Guantanamo. And the other class is sort of strange. It's the class of people in criminal confinement who are susceptible to this proclamation, the Alien Enemies Act proclamation. And their only plaintiff there is in the District of New Jersey. So their theory, their named plaintiff, there's about 32 people believed to be in this situation in various jails across the country. And their theory is it's not a habeas because they're only asking for notice. They're only asking for that he order, before they can be removed, they need to get 30 days notice and opportunity to try to go before an immigration judge. I think Judge Boasberg will be very reluctant to go there. It's too similar to where he went last time. But that first class is interesting. The other problem is that there are no named plaintiffs in DC right now, and so it's a tricky situation.
Well, so, having spent a lot of quality time over the years with the Guantanamo litigation, I will say that jurisdiction in DC, if they are in fact in U.S. custody at all, is not going to be a difficult proposition under Rasul. The difficult proposition is that the government will say these people are in the custody of the government of El Salvador, and you're going to have to at least make out a theory of constructive custody that is that jurisdiction will then depend on, and it's going to require the development of certain facts in order to establish the jurisdiction.
Yeah.
All right.
There's actually quite a good record at this point about them being in at least joint custody, that they've been outsourced.
Yes.
And so that's a pretty good case for that class. Shall I go to? I'm sorry.
Let's do DBU.
Yeah, this was another one of those. This is one of those district-wide attempts to stop people, the people from being flown out under the Alien Enemies Act proclamation without adequate notice. The striking thing, and there was a preliminary injunction issued on I guess the 18th. And the striking thing about this one, no, it was, I'm sorry, it was a TRO. And the striking thing about this one is that she actually reached some of the merits. She said, in the process of saying that the plaintiffs would have a likelihood of success, which is one of the things you need to find, she said that the AEA doesn't even apply here. She said there's no invasion, no predatory incursion, no foreign government or nation. And you might remember a DC Circuit Judge, Karen Henderson, had also found that concurrence about invasion and predatory incursion. So her there's already been a motion to stay that in front of the 10th Circuit, and that is moving fairly quickly. The response due tomorrow, Saturday at 5, reply due Sunday at 5. So we'll get some resolution of that quickly.
All right. So what about DVD?
DVD is not an Alien Enemies Act case. It's an interesting case. It's about people that are sort of in Abrego Garcia situation. They have withholding of removal. And what that means, they're removable. They came here illegally, so they can be removed. But they can't be removed to where they came from because a judge, an immigration judge, has accepted the idea that they will face well-founded, they have a well-founded fear of persecution there. And so in the past, if people, since they are still removable, in the past, if the government wanted to remove them to a third country, they would give them notice and let them, give them an opportunity to go before a judge and say, I fear persecution in that country too, or I fear torture or whatever. They stopped that policy quietly on February 18th of this year, the Trump administration did, and just began removing people willy-nilly to third countries without letting them raise this issue. And so this judge issued a TRO in March 28th and extended that to a preliminary injunction on the 18th. And they have appealed that to the First Circuit. This is going on in the cases in the District of Massachusetts. The First Circuit is not moving quite as quickly on that. And then a remarkable thing is also going on is that apparently, despite this order, some people have been removed to third countries. And this came to light, I think, yesterday or today, maybe yesterday, when the government conceded, the plaintiffs had objected that there were several instances. And apparently what's happened is some people were sent to Guantanamo by DHS, and then DOD took over, and DOD took them to the third country. And DOD, Defense Department, is not a defendant. And so they said, well, there was no DHS person on the plane, and they claim DHS didn't direct what the Defense Department did. So that's where that stands at the moment. We haven't had a judge's reaction to that. There'll be a status conference Monday.
It's the kind of thing judges love when you do, monkeying with whose custody somebody is in by way of saying that court orders don't apply to you, or just coincidentally. All right, Anna Bauer, this brings us to Kilmar Abrego Garcia himself. And so give us the lowdown.
Yeah, it was kind of a wild ride of a week with this case. On Monday, there was a joint request for a conference that was filed on the docket that was quite interesting, because included in that request was a number of interrogatory responses and responses from the government in response to the plaintiff's requests for document production. Remember, we're in the middle of this discovery phase in this case, where Judge Sines has ordered the government to, go through this discovery process to fork over documents and answer questions regarding what steps it's taken to facilitate the return of Abrego Garcia. So this joint request for a conference comes in. The parties are having a lot of issues figuring out how to move forward, because in the plaintiff's view, the government has not sufficiently responded to their interrogatory and document production request. If you read the exhibits, it's very clear that the plaintiffs seem to be in the right, because the government in its responses provide very, broad objections to questions. They invoke state secrets, attorney-client privilege, deliberative process privilege, various types of privileges, without providing any specific basis for such invocations. They additionally, throughout some of these responses, misrepresent the SCOTUS ruling. I think, to me, the most shocking part of some of these responses involved this one point when the government says that the defendants object based on the false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Now, if people remember and have read that SCOTUS order closely, that is exactly what the Supreme Court says. They say that the district court properly ordered the government to facilitate his release from custody. And then they also, miscite or they misattribute SCOTUS saying something that they didn't. They really were quoting Judge Sines. So it's kind of very, it's a huge misrepresentation. They also then seem to have this kind of internal contradiction in which they go on to say, that they've quibbled in the past about the meaning of facilitate. Previously, as we've discussed, they took the view that all they had to do to facilitate Abrego Garcia's return was to remove any domestic barriers to his return. They now say, oh, well, after the Fourth Circuit's clarification, remember that opinion from Judge Wilkinson, in which he really tried to convince the government to have a come to Jesus moment and actually comply with the court's order. They say now, oh, well, after the Fourth Circuit's clarification, we've changed our mind. We've engaged in what they call appropriate diplomatic discussions, but that those discussions cannot be revealed because it might, interfere and have a negative impact on the ongoing diplomatic relations. So they make all of these statements and of course, the plaintiffs say that this is not complying with the court's discovery order. They want a conference. Judge Sines just goes ahead and rules on it, issue an order in which you can tell she is very mad. She accuses DOJ, particularly about that misrepresentation that I noted of the SCOTUS order, of a willful misrepresentation. She largely overrules all of the objections. She says, you didn't provide any specific basis for these privilege invocations. And then she gives them 24 hours basically to fork over the rest of the discovery and then also to supplement their invocations of privilege lest they waive it. And so it seems like, we're at this moment where maybe the government is finally going to have to give up some information and actually talk a little bit about what steps they've taken. But then the next day comes and the government under seal files a motion to stay Judge Sines' order, her discovery order. And the plaintiffs file something also under seal in response, and it is styled as a response in opposition. Now, maybe it was opposition in part, or maybe there were various kind of qualifications to its opposition. But it's styled as a motion in opposition to this request for a stay. 6 o'clock, 8 o'clock rolls around, and then finally on the docket, there's an order from Judge Sines, and it doesn't provide much information other than to say, with the agreement of the parties, the discovery is stayed until April 30th. And that kind of left all of us thinking, well, what's going on there? So I'm curious if people have thoughts on that. But that's where we are now, Ben, is discovery is stayed until April 30th.
So let me be provocative and say that if I were Legal Learned and Scott Michelman and the folks who are or Abrego Garcia's lawyers, there is exactly one thing that would make me agree to staying discovery, which is a representation by the government that they are in negotiations to bring him back. And so my question is, does anybody, particularly those of you who litigate things, want to argue that there could be something less dramatic than that going on? Go for it.
Well, I'm not one of the people who litigates things. My initial thought when this is happening is that it very well might be, one possibility is certainly that they've gotten a sign that they're actually trying to resolve the situation, will be a reason for both parties to agree. An alternative could be that they've agreed to provide some of the information they were resisting providing to the judge to evaluate ex parte in camera, and the judge may request a period of time to do that. And that would explain why the plaintiffs would initially object. And then perhaps after talking to the judge and understanding this information is being provided, I need time to review it and rule on whether or not it's subject to state secrets privilege. They might be willing to concede for a short delay so the judge can do that. And then the new due date would apply presumably after the judge rules on state secrets, and then the government has to decide whether to disclose it or appeal or do whatever else they want to do to try and keep disclosing that. I'm not sure which is the right answer, but that might be one that's slightly less dramatic that I think would be consistent with how it's been done in other cases I'm vaguely aware of, but folks can feel free to correct me.
Roger?
I sort of doubt they would have agreed to that, especially because their invocations of state secret have been so frivolous in the past. The only other thing other than what Ben suggested might be a compromise involving getting him to a third country where if his family is so worried about him spending more time in prisons, even lighter prisons as he apparently is now, in El Salvador. Maybe they could agree on a, Guatemala or something. That's 'cause
Palau sometimes used to take Guantanamo detainees. I hear it's a nice island paradise.
that's the only other thing. But the fact that they agreed to it, I thought that Abrego Garcia's lawyers agreed to it, and given her fury, like Anna said, and the fact that she so wanted to get this done by April 30th, and now she's delaying everything till April. It has to be something big.
All right. Roger, we have another 3-letter initials for you to describe. Who is JOP?
JOP is new, and it's an interesting case. JOP is probably a mother or a wife of some of the person whose name is Christian, or Chris. I don't know how that would be in Spanish. So this is a weird case that goes back to 2019. It's District of Maryland. It's before a Trump appointee, Stephanie Gallagher. And the remarkable thing is that this has become the second case where a judge has ordered the government to facilitate the return of somebody that's in Sacat and in El Salvador. And so the case was a class action on behalf of AUCs, or UACs, which is unaccompanied alien children that came in and were applying for asylum. And what it sought was that they would get a chance to litigate their asylum claims to a final judgment before they were removed. And so there was much negotiation, and there was a settlement reached, and the settlement was approved in November 2024 when some other important things happened. And then on March 15th, Christian, who was now 20 years old, I forget how they detained him, but he was removed to Sacat. And the government argues that says they moved him within the AEA proclamation, the Alien Enemies Act proclamation. And so the judge was saying, you violated the class action agreement. And they said, well, first of all, he has to bring this in a habeas. And she says, no, it's not a habeas, it's a contract dispute. We have a settlement, you violated it. And the other argument was the AEA changes everything. It trumps everything. And the judge said, no, it doesn't. And she actually, and Anna can correct me on this if I'm wrong, or maybe other people, but I think she actually goes a step beyond what even Judge Sines has said. She says that the defendants must facilitate his return, and she says facilitating his return includes, but is not limited to, defendants making a good faith request to the government of El Salvador to release him to U.S. custody for transport back to the U.S. to await the adjudication of his asylum application. And I don't think she's gone quite that. I don't think Sines has gone quite that far and says, you must ask El Salvador to release him, even though it seems painfully obvious. I don't think anybody.
I think Sines didn't want to go that far because
Yeah.
she's worried about what the Supreme Court would do with that.
Yeah, I agree. So I was a little surprised that she seems to go a step further. But anyway, it's quite an interesting development, and like I said, it's a Trump appointee.
All right. Preston Marquis, we have another 4-letter acronym, but this one is not an initials. What is AAUP versus Rubio?
Certainly. So AAUP, not AARP, but AAUP, it's the American Association of University Professors v. Rubio. This is the lawsuit being brought by the Knight Institute to challenge the Trump administration's recent practice of revoking the visas of students who have been associated with pro-Palestinian advocacy, detaining them and then deporting them. So non-citizen students and faculty, espouse in some manner, a degree of pro-Palestinian ideology, and the Trump administration has been moving aggressively to find those individuals and to revoke their student visas. That's the conduct at issue in this lawsuit. A couple of days ago, on April 23rd, we had an initial hearing in the District of Massachusetts. The Knight Institute has filed for a preliminary injunction, and it went before Judge Young, who had held quite a hearing. For those who listened in, you might recall, but I'll describe it briefly here. So it started as a pretty routine hearing where Judge Young sort of brings all the parties together, but he very quickly, you can tell that Judge Young is, I think, a little concerned about sort of the ability of the court to apply the relief that the plaintiffs are seeking, which is, a broad injunction, sort of enjoining the Trump administration from enforcing this practice. And Judge Young is clearly trying to grapple with sort of how much equitable relief, he can bring in this circumstance. In no small part because a lot of what the government is claiming in opposition to this, and a lot of what Judge Young has to grapple with, is sort of what exactly constitutes the contours of this policy. The Knight Institute is largely referencing the executive order and public statements being made by senior Trump administration officials that indicate that the Trump administration is sort of affirmatively going after these non-citizen students and faculty on the basis of their views. But if you listen to the government, it's more of a broad pattern of enforcement, and not necessarily a per se policy. And so there's a little bit of a shell game going on here, and the question is like, which side is going to be able to convince Judge Young that there is in fact a policy in place here that is sort of underlining these ideologically motivated deportations. What I would also point out here is the Knight Institute, in bringing this lawsuit, has to be particularly scrupulous to meet the standing requirements to survive jurisdictional attacks by the government. So the Knight Institute, in essence, is bringing a listener's right case here. They are saying that it's sort of the second and third order effects of these deportations and their impact on free speech on these campuses, on the associations themselves. It's having a chilling effect on and ultimately preventing sort of the American Association of University Professors specifically, but also campuses broadly, from benefiting from a more robust sort of speech and debate on campus on some of these issues. And so just moving forward with Wednesday's hearing, Judge Young was initially inclined to very quickly sort of flip what was a hearing for a preliminary injunction into a full-blown trial on the merits, invoking his authority under FRCP 65A, I believe. And I think from Judge Young's view, he's really trying to test the sufficiency of the evidence that the Knight Institute is bringing. How much can the public statements that are, very out in the open for those of us in the world be translated in a court perspective into suggesting that there's actually a policy here that the court could enjoin. And so moving through the hearing, there was a bit of back and forth. Judge Young was grappling with that. Ultimately, it became clear that both sides were actually ready to argue the PI as a potential motion to dismiss. The government was clearly, if you read the government's brief, a lot of their legal arguments really favored dismissal of the entire lawsuit. And Judge Young was willing to sort of flip the hearing from a hearing for a preliminary injunction into an actual full hearing for a motion to dismiss. And so he called a small recess, and then the litigants came back and laid out some of their arguments there. I won't go through the full thing, but I think it's just worthwhile to summarize that the government's primary attacks, as I mentioned, are largely jurisdictional. So the government is trying to claim that the district court doesn't have jurisdiction over this based on how the Immigration and Naturalization Act, the INA, sort of specifies a very specific practice for ruling on immigration procedures. The government also again tried to target these redressability concerns and tried to knock the Knight Institute out on several theories related to defective standing. And then also the government also attacked some of the claims on the merits and pointed to how, at least from the government's perspective, even if you accept that there is a policy, which the government doesn't, ultimately there's a lawful core here, which is the government saying that the government is actually targeting unlawful behavior and not targeting speech itself. The Knight Institute, in refuting those claims in the motion to dismiss context, pointed out that they are that again, this is not a case being brought on behalf of the non-citizens themselves. It's actually not subject to the INA because, again, the AAUP is bringing a listener's rights lawsuit on behalf of the U.S. citizen members and associations. So some of the jurisdictional attacks that the government is bringing don't actually apply from the Knight Institute standpoint. And then I think, you know, if just sort of going back to the First Amendment, ultimately, you know, if the Knight Institute is successful in sort of brushing the government's jurisdictional claims away, this is ultimately going to get to a case about the First Amendment and sort of how much can the government very explicitly, go after non-citizen individuals on the basis of some of their views and use that as the basis for deportations.
All right. So, Scott, let's talk about the Student and Exchange Visitor Information System case. We mentioned this briefly last week, but there's been a kind of a dramatic development in it. So bring us up to speed.
Absolutely. Just really earlier today, just in the last few hours, we've seen a lot of reporting break on this. Essentially, the government has indicated that the revocations it had implemented earlier this month of several files from the SEVIS system, a system that's used to coordinate the status of students here on student visas between the government and universities in various regards, were going to be restored. These were deleted earlier this month. An act that was done apparently on the basis of the fact that the people whose records were deleted had some sort of run-ins with the law, but not of a severity that would normally be considered sufficient to actually put their student visa status in danger. This actually caused widespread confusion because usually just deleting from SEVIS wasn't really clear what that meant to a lot of universities. You had cases where some students were allowed to go about their business normally, pending clarification. Others were told don't stop attending classes. So some others were under the impression that they had to leave the country, that it meant their visa had been revoked, although that's actually a separate administrative step. There's actually more than 100 cases filed, evidently, over this in more than 23 states, resulting in as many as 50 TROs or other sorts of relief over the past few weeks, indicating the government had to unwind this. So in the face of this sort of wave of action that seemed to clearly signal courts pretty consistently saw a big problem with what the government had done, it appears they've at least temporarily walked back this step. That said, they've also indicated in statements to reporters that this is just a measure while DHS develops a procedure and process for handling SEVIS records in the event of law enforcement encounters of this sort. So presumably they're going to implement a policy and explain the consequences of it, and perhaps implement it in the near future, which may lead to a similar event, hopefully with a little more coordination, less chaos in the next few weeks or months to come. Or perhaps not, they may just let it lie. For the time being, all those students appear to be back in the regular status, and they're including in the SEVIS system, which hopefully should resolve the attendant confusion.
All right, so we are in the, I think, unprecedented situation of having the reporter who broke this story in the audience today. And so I thought I would ask John Hawkinson, who's was at the hearing this morning and who made this this SEVIS case public, just ask if you had any thoughts or additions to what Scott has said.
Thanks, Ben. So I don't have a lot. I will say I was aware of these cases, but because they're immigration cases, they're a little hard to track. You can't just download the documents like you can in usual cases. And so I saw this. I was following a case about a college student seeking, their SEVIS status to be reactivated, of which there are several hundred. And this morning, the AUSA had emailed the judge a statement from ICE, which the judge felt was important enough to read out loud in the case, and then to docket the email he received from government counsel. And apparently, as that was going on, sort of the same thing was playing out in other hearings across the country, including one in Washington, where I was not. I was in Boston. So I think the general reaction from counsel on these cases is that ICE was losing the TROs. They were getting TROs that both required them to preserve the status quo by not removing people, but also ordered them to restore the SEVIS records, to actually take an affirmative action with respect to their database. And so counsel for these, I guess they're plaintiffs, generally were getting the feeling that the government was just tired of losing the litigation over and over again. And that's why they took this action. And I don't know if you want me to read the email or not.
How much does it add to what you've just said?
Well, I mean, it's the government's position. So I'll just briefly do it. ICE is developing a policy that will provide a framework for SEVIS record terminations. Until such a policy is issued, the SEVIS records for plaintiffs in this case and other similarly situated plaintiffs will remain active or shall be reactivated if not currently active, and ICE will not modify the records solely based on the NCIC finding that resulted in the recent SEVIS record terminations. ICE maintains the authority to terminate a SEVIS record for other reasons, such as if the plaintiff fails to maintain his or her non-immigrant status, blah, blah, blah.
Interesting. All right. Well, thank you for your reporting on this, John.
You're welcome. Thanks, Ben.
All right. So we have now gone 57 minutes and have just finished the immigration cases alone that are active right now. So we're going to have to speed through some other stuff. Let's start with the attacks on various institutions. Roger, do we have an update in the law firm cases? Roger,
Roger.
are you muted?
Sorry about that. Yes, we had hearings in the Perkins Coie and Wilmer Hale cases. They are these are the final hearings. We'll get either a permanent injunction or theoretically a dismissal. It will be a permanent injunction. I'm pretty confident in both cases. And we had a Lawfare Live afterwards, so I won't say much about this. But Beryl Howell at one point used the word shakedown. I think that's a bad sign for the, for the government in defending it.
Yeah, you always get a little nervous when the government, in a challenge to a government policy, the judge refers to the policy as a shakedown.
Yeah. So I think since we have a lot to cover, I'll leave it there. I have a story online about that sort of, if you missed the Perkins Coie thing, there were glitches in the phone-in line. I emptied my notes onto the site so you can see what happened there.
And Roger and I had a separate conversation about these, which is available on the YouTube page. All right. So meanwhile, the American Bar Association is filed suit. Scott, what is the ABA upset about at the administration?
Well, like law firms, like universities, they have been targeted by their own set of retributive actions, this time primarily coming from the Justice Department and what they describe as the Blanche memo from Deputy Attorney General Todd Blanche, basically directing Justice Department employees not to engage with ABA in a variety of capacities as members of committees, participate in different sorts of official activities, which was quite common, obviously, for Justice Department attorneys prior to that. And then this suit ties that, rightly or wrongly, but in their view, to a related action, which is the cancellation of a number of grants that were going to the ABA, primarily related for violence against women issues from their OVW, which I think is the Office of Violence Against Women by Action. Not sure about that. James, you may know, and you can correct me if I'm wrong. They've essentially filed a lawsuit that bundles a lot of constitutional arguments. I think is one of the more complete sets of constitutional challenges we've seen from 4 different angles on the First Amendment, to due process, equal protection challenges, spending clause challenges, as well as a good old Administrative Procedure Act challenge to this whole array of actions, the cancellation of the grants and those Blanche limitations, memo limitations. So we will see where this goes. This isn't the first time they filed suit. Of course, they were also plaintiffs in the administration, in the litigation challenging the administration's cancellation of a variety of foreign assistance grants earlier in the administration. But this action has been on the books for a few weeks. I think we were expecting a legal challenge, and now it looks like we see it. We have it.
Sorry. I was not mute. I was muted myself. All right. So this brings us to universities. Harvard has gotten in on the litigation action. James, what's Harvard's beef? It's just like $2 billion. They've got plenty of money.
Yeah, well, lots of billions lying around. No, as was widely reported earlier this week, Harvard, I think, is, if not the first, certainly one of the first universities to really push back and to take the Trump administration to court. So they filed a complaint on the 21st of April. The core of the complaint is a funding freeze case, and we've talked about those here. And there have been a couple. States have filed them, nonprofits have filed them. This is Harvard saying you can't freeze our $2.2 billion, at least $2.2 billion. The complaint refers elsewhere to other monies that may also be frozen, or their threats of freezing. The counts in the complaint are pretty similar to what we've seen in other cases, with the one difference of more of a First Amendment emphasis, but the mechanism through which the claims are brought are Administrative Procedures Act. They're sort of ultra vires act. Because this is in the education context, there's a bit of a difference, which is the thrust of Harvard's argument is that essentially the administration is using as a pretense the view that Harvard is not doing enough to combat anti-Semitism on campus, and thus is out of compliance with the 1964 Civil Rights Act, and that there is a mechanism under that under that law to kind of to pull back some of the funding. But the administration hasn't actually followed what is the framework that statute lays out, and is essentially trying to grab funds that have nothing to do with efforts to combat anti-Semitism. The complaint does a nice job, I think, in laying out the relevant statutory background, all of the efforts that Harvard has in fact taken to try to combat anti-Semitism, and how, in addition to the administration's efforts to just try to freeze funds willy-nilly, that's essentially like what the administration is trying to do is also get its hands all over Harvard's academic decision-making, hiring of faculty, influencing admissions decisions, funding of student groups. And so I think the complaint does, as I said, a very effective job in laying this all out. Toward the end, I think it also does a nice job in saying, although this particular case is just about the funding freeze, Harvard has also become the target of other sort of components of the federal government. It alludes to congressional investigations, records requests from the Department of Education. And then, as has also, I think, been fairly widely reported, threats that the IRS will try to remove its 501c3 charitable tax exempt status, and that these are all other things hanging out there. They're not formally part of the complaint here. And in fact, that if there is a tax action that wouldn't be brought, this was brought in the District of Massachusetts, it couldn't be brought here. But it's I think a very well done complaint and one worth reading. No action since then, interestingly, at least it's happened since we've started. Harvard has not sought a temporary restraining order or a preliminary injunction. That may be coming, but that is not yet on the docket.
All right, Scott, ICC. What's when I think about the poor beleaguered people oppressed by the Trump administration, the ICC isn't high up on my list, but yet maybe it should be.
Well, they are being sanctioned, so maybe it really genuinely should be. But relatively small number, actually just kind of the head prosecutor of the ICC currently. Regardless, we now see two legal challenges to the International Emergency Powers Act-based sanctions the Trump administration has imposed against the ICC, and specifically the chief prosecutor of the ICC, both being filed by groups that engage with the ICC in communications, in some cases to share evidence or analysis of legal issues. One case is filed by a pair of law professors in New York, in the Southern District of New York before Judge Furman. The other is by a pair of human rights investigators and activists represented by the ACLU in the District of Maine. They make a similar set of arguments, which is fairly interesting if you are an IEPA nerd, as I am, and hopefully you are or will be soon, in that they launch not just constitutional challenges to First Amendment-based actions, the idea that these are speech protections in engaging with the ICC, but that in fact it is also a violation of the Berman Amendment. This is part of the IEPA that specifically limits how IEPA can be applied to informational materials and communications materials. Slightly awkwardly worded amendment, interpreted very narrowly by the government, but applied in a number of contexts by courts to say, well, this is supposed to be protective of the First Amendment, and so we're going to read it actually in various ways that protect different speech-related activities or materials related to speech. And here they essentially argue when we trade briefs, when we trade documentary evidence of international crimes, that is speech protected by the Berman Amendment and by the First Amendment. And there's also some due process clauses related to certain ambiguities in the executive order in the New York case. It's an interesting set of litigation. We've seen similar arguments made before in the material support for terrorism context that led to the Humanitarian Law Project case in 2010, which probably would be an obstacle for some of these claims. But here in the IEPA context, different statutory basis, you do have the Berman Amendment, which is a huge help if the courts actually decide this does fall within the scope of those. So actually a pretty interesting set of cases here. We will see where they go. Right now, we're only at the stage where we have the complaints for those.
All right. James, we had a preliminary injunction granted against the president's election integrity EO, which frankly, I had forgotten that he had issued. So remind us what the election integrity EO is, and then why Judge Colleen Kohler-Catelli, which is the judge, I'm sorry, guys, with the hardest name to pronounce live, just not because there aren't judges with harder names to pronounce, but because it's a tongue twister. And you trip over your tongue when you say Colleen Kohler-Catelli. Try it 5 times quickly. James, what did she do?
Well, I just have to say, at least she doesn't sit in Woonasquatucket, because I think that would just be asking too much.
Right, because if she were
if
she were from the district of Lake Chargagagog, Manchagagog, Shabunagungamog, we'd all be screwed.
Yeah. No, I think it's fair to say it's the election integrity executive order and this litigation probably hasn't gotten the coverage that it might in what one might say normal times, just given the very steady fire hose stream of litigation and executive actions coming our way. But at the end of March, the President Trump issued an executive order that essentially directed something called the Election Assistance Commission, which is a federal body I'll say more of, to take various steps to impose requirements around federal elections, like requiring proof of documentary proof of citizenship, not allow for counting of ballots after election day, require certain entities not to distribute federal forms, registration forms, unless they were those entities were making assessments about citizenship. This is all against the backdrop, and I should say, Judge Kohler-Catelli's opinion, which dropped yesterday, is another of these magnum opus, I guess, 120 pages, and does a nice job of laying out some of the background and actually walking through a lot of the stuff that we spend a good bit of time talking about these days in terms of, how does the standing and cause of action and ripeness, how do all of these play out? So if anybody who's just trying to work through that is interested, I would commend it to you on that alone. But the sort of concise background is that under the Constitution and the statute and various federal statutes, the organization of federal elections is actually committed to the states with Congress as a backdrop and does not provide a role for the president. And so Judge Kohler-Catelli's opinion starts by saying this is ultimately an opinion about the separation of powers, about an effort by the executive branch to reach its hands into an area that is committed elsewhere. And so in that respects, I think shares a lot of similarities with some of the other cases that we discuss here and issues that we discuss. The challengers here, it's actually two consolidated cases. One set of challengers were nonprofit, nonpartisan organizations like the League of Women Voters and other groups that carry out registration efforts. Another group is essentially Democratic Party affiliates, including Hakeem Jeffries and Senator Chuck Schumer, who also joined the litigation. The challenges, I alluded to sort of some of what the executive order did or purported to do. The challenges were to 5 different portions of the executive order, 2 of which are now enjoined under Judge Kohler-Catelli's ruling, and 3 are not. The 2 portions that are enjoined, one is, as I already mentioned, is essentially an effort that requires the Election Assistance Commission to prove to itself require documentary proof of citizenship. And I promised, and I realized I did not fulfill the promise of explaining briefly what the Election Assistance Commission is. It was an entity created under federal statute in the early 1990s to try to kind of improve how federal elections are run. It's another one of these bipartisan balanced entities that is an independent agency operating independently of the executive branch, though formally sitting in it. So kind of poses some of the questions and concerns that we have seen when we've talked about the cases sort of like in the Humphrey's executor vein. So the challenge to the efforts to impose a documentary proof of citizenship is enjoined because Judge Kohler-Catelli finds that is essentially the executive branch trying to step on and add to existing statutory sort of congressional requirements, and is the executive branch operating ultra vires. The other provision that is enjoined, is a provision that directs various federal agencies, which as part of their provision of services are giving out standardized federal forms, which is a way that many people register to vote, that essentially conditions the giving out of those forms on, again, a citizenship assessment. And the judge finds that for sort of similar separation of powers reasons is beyond the scope of what the executive branch can do. The reason the other provisions aren't enjoined, those provisions are things like directing agencies to keep databases, or condition funds to states, or direct the attorney general to enforce certain laws. And basically, Judge Kohler-Catelli finds that in those instances, it's either the wrong plaintiffs that are suing. In other words, you need to get the states up there to challenge some of those issues. or it's just a prudential ripeness problem. We are just too early on. It's unclear whether the directives are anything other than a guidance as opposed to an actual kind of enforceable legislative rule. So bottom line, we've got some of those provisions enjoined, others not. And so far, again, this only dropped yesterday, but so far the government has not yet noticed an appeal.
All right. So I do want to get to the audience questions, of which there are 5. So let's keep answers on the remaining matters brief. James, we've had some developments in the transgender military ban. What's that looking like right now?
Yeah, and so keeping this very brief, these are challenges that have come out of the Western District of Washington and the District of Columbia to an executive order that issued at the end of January that was banning individuals diagnosed or having gender dysphoria. It is widely described as the transgender ban, but I think that's an important point because that is what is relevant in the litigation at this point. In the litigation out of the Western District of Washington, the judge granted a preliminary injunction, as did the judge in the District of Columbia, Judge Honoreus, finding that the ban likely violated the equal protection rights of transgender military members. The Ninth Circuit denied the government's stay pending appeal. The DC Circuit heard argument on it this week. Not much to say, particularly given time constraints here, other than the government attorney there announced what then, in fact, we see, which is that the government was going back to the Supreme Court. And so the government yesterday sought emergency, again on the emergency docket, the Solicitor General seeking Supreme Court intervention in the Ninth Circuit version of this. The brief version of the argument that the government is making is that the courts below have erred in subjecting this executive order to heightened scrutiny, to intermediate scrutiny, because really, in the government's view, this new order is, because it's based on gender dysphoria, is rooted in a medical condition and is subject to something known as rational basis review, a much less demanding standard. And the government says there are rational reasons why the Secretary of Defense would conclude that transgender individuals or individuals who have been diagnosed with gender dysphoria can't serve in the military. So response to be filed May 1st from the challengers to the executive order.
But we have no indication of that from either the DC Circuit or the Supreme Court by how they feel about that argument.
No, it's interesting. It didn't come up much. The different levels of scrutiny really didn't come up much in the argument itself. The point that the government makes in its filing to the Supreme Court, filed to yesterday, is, look, Supreme Court, you actually saw a version of this during the first Trump administration in a challenge to a Mattis policy. And it seems like there, though I'd have to go back and look. I haven't looked, but it seems like there you thought rational basis review was appropriate. So you should do the same here. There's really no distinction. But we'll see if I'll be interested to see what the opposition comes in, and because we've just got the government's characterization of both the relevant procedural history and the arguments at this point.
All right, Roger. We missed this last week for time reasons, but the dismantling of the CFPB continues apace. What's going on in that litigation?
So to get the timeline, Judge Amy Berman Jackson had issued a preliminary injunction March 28th. She had found there was dismantling of the agency, very much bad faith. They were really just trying to wreck it. To demolish it, to end it. And the evidence was strong. April 11th, a conservative panel of the DC Circuit, the government sought a stay pending appeal, and the conservative panel granted a partial stay. They said parts of the order can stay in effect, but parts can't, and they would allow reductions in force, RIFs, if they were based on particularized assessment of whether employees were necessary to perform the agency's statutory duties. 3 days later, the CFPB announced RIFs that were deeper than the original RIFs. They would take the agency from an original 1,700 people or so down to 200. So she held last Friday, there was a sort of an enforcement hearing to see whether they were violating the injunction, even as it was modified. She found that they were. There will be a hearing Monday, where she takes more evidence. And I guess, and meanwhile, the DC Circuit, the government has appealed that ruling back to the DC Circuit, and I believe that's fully briefed, and we could get a ruling any moment.
Finally, Scott, two categories of cases, one involving tariffs and the other involving the foreign assistance grant terminations. Bring us up to speed, high level of altitude about what this body of stuff looked like this past week.
Sure. At a very high level, first on the tariffs issue, we are now seeing, by my count, 7 at least, although my suspicions are more looking out there, cases filed challenging President Trump's imposition of tariffs using the International Emergency Economic Powers Act, IEEPA, the statute I mentioned earlier, usually used for sanctions, also used in this case for tariffs, somewhat unusually and controversially. 5 of those actions appear to be targeting the kind of worldwide tariffs President Trump has imposed. One each is challenging Canada or China specific tariffs, although also often incorporating the worldwide as specifically related to those countries. And the 7th, I should say, I haven't been able to find the docket for, but it's referenced in one of the other cases. That's Barnes v. Trump before the Court of International Trade. All we've really seen happen in this so far is that about half of these actions are in the Court of International Trade, a specialized federal court that handles trade matters and has exclusive jurisdiction over a variety of trade matters. And then half of them have been filed in different district courts around the country. And this includes cases by California, which is filed in Northern District of California. Another matter has been filed by a number of other states, Oregon and a couple of companion states. Some cases have been filed by toy companies who are importers. A number have been filed by a number of kind of cross-industry groups. And then one notably has been filed by a group of Blackfeet Native Americans that makes very interesting, very unique arguments about how tariffs are affecting them and relates to certain rights that their Native American community has and other Native American communities have and how they're handled under the law. Really interesting case. It's Weber v. Department of Homeland Security. All that's to say is that so far there's a big debate over whether these all need to be consolidated in the Court of International Trade and perhaps even as kind of one big matter. I don't know if the latter is going to take place, but we've seen at least one case rule at the urging of the government that it should be transferred from district court to the Court of International Trade. Other courts seem less convinced that this particular matter actually is within the exclusive jurisdiction of the Court of International Trade. IEEPA actions normally are not, but they also are not normally used to impose tariffs. So that's part of the confusion in this case. And then we did see one TRO denied in the one matter that's already before the Court of International Trade. This VOS selections v. Donald Trump. This is one represented by a group headed by Ilya Soman, who wrote a piece on us for it in Lawfare this past week, if I recall correctly. But the TRO was really pretty minimal analysis, not even a memorandum opinion that I saw, really just focused on the fact that there's not much irreparable harm here because it's mostly collecting taxes the government can pay back if it loses. So that's where we are now. It's going to be big litigation and the source of a lot of focus in the weeks and months to come, because this could be a pretty seminal determination about the sustainability of Trump's policies around tariffs and the use of IEEPA moving forward. The other cases regarding the whole universe of foreign assistance cases we've seen, I will skip most of it, or minor developments for most of it. The most notable one we've seen, however, is that Judge Lamberth in district court here in DC in Witteka-Suwara v. Lake, pardon me, I'm sure I'm mispronouncing that, essentially ruled and issued a preliminary injunction saying that all of the U.S. Agency for Global Media projects whose funding was cut by the Trump administration should be restored. That means Voice of America, Middle East Broadcasting Network, and Radio Free Asia. Radio Free Europe and another technology-related program had actually already had their funding restored, so he did not extend the PI to them. This is good news and a big development, particularly for VOA and other folks who are working there, because it does mean this grant money should be coming back Trump administration has appealed to the DC Circuit, though. So that's the next step to look out for on that. Everything else, I think we can hold on until next week.
All right, let's go to audience questions. Matt asks, this is a question we have batted around internally as well, asking only half in jest if we take at face value the administration's argument that Tren de Aragua is a state actor conducting a hostile military invasion of another country. Do the laws of armed conflict apply to that situation? And for example, does the use of prisoners for propaganda by members of the US government amount to a war crime? So let's just say that Matt's question does point out the incoherence of the claim that Tren de Aragua is a state actor with which we are at war. There is no authorization to use military force against Tren de Aragua, nor has the administration contended that Tren de Aragua fighters are fighters within the meaning of the laws of armed conflict. But the point is, Matt's point should not be taken literally, but it is, I think, a good illustration of the incoherence of the argument. Scott, as one of our law of armed conflict people, do you have anything to add to that?
All I would say generally, two things, one domestic, one international law to bear in mind here. First, we are interpreting the meaning of these terms for the purposes of a specific statute, Alien Enemies Act. That doesn't mean they have the same meaning as they might under international law. You might have a predatory incursion or a war in a foreign country, even for the purpose of the Alien Enemies Act. That does not mean it would be the same thing under international law. It might be, but they don't necessarily have the same definitions. You'd have to look at the intent of the authors of that statute. The second point I would make is that also all violations of international law of armed conflict are not necessarily war crimes. So I actually think using individuals for propaganda purposes, I'm pretty confident, not 100%, I don't have this part memorized, but I'm pretty confident that is a violation of the law of armed conflict, but it's actually not a war crime. That is a subset of more severe crimes, usually considered war crimes. For purpose of US law, War Crimes Act, almost positive it's not a war crime. Pretty positive.
Yeah, I think that's right. All right, Joyce asks Anna Bauer, would anyone, i.e. Anna Bauer, like to speculate about whether SCOTUS's Saturday night emergency action was an administrative stay, or if not, what it is and what's next?
Oh gosh. I mean, I don't know. I feel like Roger might have more thoughts on this than I do. I'm not entirely sure. It's kind of, it feels like you can't really classify what they did on Saturday. And it is quite interesting.
Which is kind of Justice Alito's complaint. Roger, do you have thoughts on whether it's an administrative stay or something else?
I don't remember how it was styled, but it seemed, given that it occurred before the Fifth Circuit had ruled, and it was a very emergency thing. James, do you remember?
Yeah, I mean, I don't think the court used the magic words as it sometimes does of saying this is administratively stayed. It in fact quite clearly said the government is not to remove any of these individuals pending further order of the court. I mean, as a functional matter, I think it operates like an administrative stay, but certainly was delivered in much more direct language and with all of the kind of interesting procedural complications that we've alluded to and that a lot of reporting has discussed.
Although administrative stays are usually used to allow for briefing, and this was actually briefed by both sides, not like the full usual cycle. So I actually think it might be something more akin to, like, I guess, a TRO or something to that effect.
Bottom line, we're not sure, which is sort of the point of the question. Andrew asks, should we abandon hope that Secretary Hegseth will ever face accountability for what appears to be serious national security breaches? Are we going to have to hear the deflection but her emails for the rest of time? I would just say the answer to that question is very probably yes. But I will note that, this administration does not last forever. And statutes of limitations are longer than its remaining time in office. However, as I have said before, I don't think these are very likely prosecutable breaches in any event. And so I think the likely discipline, to the extent you ever see any, would be administrative. David has a very long question, but so I'm going to read only part of it. As the government starts kidnapping people, one would think that the first thing to happen is that the government has to defend the applicability of the AEA to the present situation, and that the deportations should stop immediately until they do so. Why doesn't our system allow the most natural response to the government's heinous actions, which is to front end the discussion of the legal applicability? Would the same thing happen in other countries? So very quickly, this is the significance of the ruling in Colorado that I believe Roger talked about earlier. And yes, I think the reason it has not really come up that much so far is because we've been trying to deal with getting stays and TROs and preventing immediate deportation. We haven't been litigating the actual merits of any of these detainees' claims. As soon as we do so, the applicability of the AEA, another hard one to just say quickly, will come up almost immediately. Finally, do you have something to add to that, Scott?
Well, just to note, his question is actually framed towards detention, not removal, which may be part of the confusion here. These people actually aren't being detained on the basis of the AEA, although the AEA does allow that. If you recall, the original challenge before Judge Boasberg actually specifically said we're not challenging detention, we're challenging our removal under the basis of the AEA, or at least the government isn't exclusively relying on the AEA. So the fact they're being detained doesn't necessarily vindicate or use the AEA because it's not exclusively what they're relying on. So if they don't actually get removed, they haven't kind of used the AEA yet in most of these cases, I believe. Certainly with the initial case, that was the sequencing as I understood it.
Finally, last question, guesses on the first finding of contempt for an administration legal representative, days, weeks, ever. I will just say, I don't know if anybody else has a prediction here. I would think that in order for that to happen, you would have to have a lawyer do something that was outside the bounds of what the courts are expecting from lawyers representing this administration. And you'd actually have, this is beyond sanctions, what you're talking about. You'd actually have to have an order that binds the lawyers. Usually the orders are directed at the clients. Does anybody have anything to add to that? All right, we are going to leave it there, folks. Thank you to Anna, to James, to Preston, to Roger, to Scott. And we're going to be back next week. And, the docket will be full, I'm sure. Thank you all for joining us. And remember, if you haven't done so already, go become a material supporter of Lawfare. We need your support. If you are using these live streams and finding them valuable, become one of the people who makes them possible. You can do that at lawfaremedia.org/support.